Hello and welcome. If Border Patrol agents arrested someone you care about for transporting undocumented migrants, then you're probably wondering, how quickly can I get them out of jail? In this video, I will answer that question and show you how federal bail hearings work in San Antonio and Del Rio federal courts. I will also tell you what factors judges consider before deciding whether your loved one goes home or stays in jail. My name is Genaro Cortez. I'm a San Antonio criminal defense attorney, and for more than 20 years, I've represented clients in San Antonio and South Texas, including people charged with federal transporting crimes. Before we begin, I want to point out that this video is for informational purposes only and is not intended as legal advice. If you have an 8 U.S.C. 1324 case pending in the Western District of Texas, then please always speak with a qualified attorney to get legal advice tailored to the specific facts of your case. After Border Patrol agents arrest a person in the San Antonio or Del Rio sectors of the Western District of Texas for a federal alien smuggling crime, they will take him to the Border Patrol station for both interrogation and booking. The best thing to do in this situation is to ask for a lawyer and remain silent. In addition, do not consent to a search of your cell phone or other effects. If your loved one calls you from a Border Patrol station, do not talk about the facts of the case over the phone. Wait until you speak with an attorney so that your attorney can schedule a confidential meeting with your loved one. This will protect a person's constitutional rights against self-incrimination. After the arrest, police will take you to federal court for your initial appearance before a magistrate judge. This hearing is important for several reasons. First, the judge will give you a copy of the complaint and affidavit. The complaint tells you what crime the government says you committed and where you committed it. For example, the complaint will tell you the crime happened in Del Rio, Eagle Pass, Kinney County, or Bexar County. Where the crime happened matters because it will determine if your case goes either to the Del Rio Federal Courthouse or the San Antonio Federal Courthouse. In addition, the affidavit establishes the facts that support probable cause to arrest you for that crime. However, this does not mean you're guilty of any crime. It is simply a legal mechanism to get your case started and into the federal court system. You always have a right to plead not guilty and fight the charge down the road. Second, the magistrate judge will advise you that you can either hire your own attorney or request the court-appointed attorney to help you out. If you cannot afford an attorney, tell the judge. The judge will then determine if you qualify for appointed counsel. If you do, the judge will appoint an attorney to help you. On the other hand, if you can hire an attorney, then I strongly recommend you hire one as soon as possible. The sooner you act, the faster your attorney can visit your loved one in jail and start moving the case forward. Finally, remember, an attorney can't promise you specific results, but they can give you their time, experience, and best efforts to help you or your loved one get the best possible result in your case. If this information is helpful, then please click the like button below and subscribe to our channel. Also, I plan on doing more informational videos on how criminal law cases work in San Antonio and South Texas. If you have suggestions, then drop them in the comment section below. One question family members frequently ask me is, how long before we go to court for the bail hearing? The local practice in Del Rio and San Antonio is that bail hearings happen at least 3 days after the initial appearance. But usually that first bail hearing gets pushed back even farther than those 3 days. This is to give defense lawyers time to meet with the client and prepare for the hearing. Here's how it works. After the initial appearance, the court will likely reset your case for 3 days. If you qualify for court-appointed counsel, then the judge will appoint a lawyer and the lawyer will schedule a jail visit with you at the local jail, usually in Valverde Detention Center, or if it's a San Antonio case, at a jail near the courthouse. If you want to hire an attorney, then your family members can use this time to search for and hire an attorney to help you with your case. In short, it takes about a week from the initial appearance to go to court for the bond hearing. Now let's talk about preliminary and detention hearings. Here's a little context to help explain the process. When Border Patrol agents arrest a person for transporting aliens, federal law requires the courts to hold 2 hearings. One is a preliminary hearing, The other is a detention hearing. These are actually two separate hearings, but judges often hear them in the same setting on the same date. A preliminary hearing is a probable cause hearing. The judge must decide if there's probable cause to believe the person committed a federal crime. This is why that affidavit attached to the complaint is so important. It tells the judge and the defense what facts the prosecutors are relying on to charge a defendant with a federal crime. In a majority of cases, judges often decide there is probable cause to believe the defendant committed a crime. However, this does not mean the person is guilty. It only means the judge believes there's enough evidence for the case to move forward. As a result, many lawyers often advise clients to waive the prelim hearing so they can focus on the bail hearing. Before the court date, the criminal defense lawyer will meet with a client to decide if they should waive the preliminary hearing. Here's a pro tip. Waiving the preliminary hearing does not hurt your chances of getting out on bond. There are also tactical reasons to either waive the hearing or to move forward with it. Your lawyer will meet with you before your court date to discuss the options and figure out the best option for your case. Now let's talk about the detention or bail hearing. After Border Patrol agents arrest you for a federal alien smuggling crime, you can ask a federal judge to let you out on bail. Here's how that process works. In federal court, the detention hearing is the bail hearing. It is the first major court hearing after the arrest. Notably, the bail hearing is governed by the Bail Reform Act of 1984. Under this law, judges ask two questions before they decide if a person qualifies for pretrial release, i.e. bail. First, they will ask, if I give this person bail, will that person show up to all their future court dates? Second, if I give this person bail, will they follow the rules of will they follow the rules of pretrial release, or will they be a danger to the community while they're out on bond? If the judge decides or hears evidence and decides that there are no reasonable combination of conditions that will assure a person that will show up to court and protect the safety of the community, then more likely than not, the judge will deny your bond and you'll have to wait in jail until your case is resolved. Consequently, the defense will put on evidence at the bail hearing to show that you will appear in court and that you will follow the rules of release. Now let's talk about scenarios where a person has a good chance of getting out on bail. Generally speaking, a person is a strong candidate for pretrial release after a federal alien smuggling arrest if the person is 1. A U.S. citizen, 2. Has no criminal history, 3. Has a job or is going to school, 4. Shows strong connections to the community, and 5. The facts of the case are typical for an alien smuggling case in the South Texas. A typical transporting case usually involves a traffic stop along Highway 90 between Del Rio and San Antonio, or along IH-35 between Laredo and San Antonio. During the traffic stop, police will usually find between 1 to 5 passengers seated normally in the car. There is no high-speed chase, there are no guns, and no one is hurt. Surprisingly, this fact pattern covers a large number of cases. If your case looks more like this, and the other 4 factors I mentioned before are present, then you are likely a good candidate to get a bond in your case. However, remember, the decision to get bond rests solely with the judge, and sometimes even in typical cases, the judge may deny bail. In contrast, there are also cases where a person is not likely to get pretrial release based on certain factors. For example, if the person is not a U.S. citizen and has no legal status to be in the country, 2. There is a high-speed chase, a rollover crash, or an accident caused by the defendant during the crime, 3. People are hurt or killed during the crime, 4. The person is out on bail, on probation, or parole for a different crime before police arrest them for the federal alien transporting crime. In addition, if the person has serious criminal history, and finally, if the person has a record of not showing up or following the rules of pretrial release, bond, or probation in other cases. So what does all this mean? If your case is covered by some of these negative factors, does it mean a judge will not give you bail? Not necessarily. This just means that you're facing a tougher fight to get bail after a federal alien transporting arrest in South Texas. And more importantly, the Bail Reform Act of 1984 gives you the right and opportunity to rebut these facts and to show the judge that 1. You will show up to all your court dates, and 2. You won't be a danger to the community if you're released on bail. At the federal bail hearing, you will likely need a third-party custodian to testify on your behalf. A third-party custodian is a person who will agree to supervise you while you're out on bond. If the person does not follow the rules, then the third-party custodian will report the violations to the court. You can also use this person to show the court that you will show up to court and follow the rules. For instance, if the third-party custodian knows, they can testify about the fact that you're working, that you're going to school, that you have a steady job, and that you have strong ties to the community. They can even introduce your work records, pay stubs, school records, proof of housing, or any other evidence that they have personal knowledge of that will show the court, that will help the judge answer those two questions we talked about earlier. Accordingly, you want to make sure your third-party custodian is a credible and responsible adult and is willing to testify on your behalf. This means that your third-party custodian should be 1, a U.S. citizen or legal permanent resident, have a stable job, or be retired, or have a good reason for not working, not be on bond or probation or parole for a different crime, and finally and most importantly, your third-party custodian must be a stable person, anchors or roots in their own community. Here's another pro tip. Sometimes judges will require the third-party custodian to sign the defendant's unsecured appearance bond as a surety. Other times, the custodian simply agrees to supervise the defendant without assuming financial responsibility. Make sure you talk to your third-party custodian about these possibilities before the federal detention hearing. Sometimes people are willing to testify on your behalf, but they're not willing to sign that security bond on your behalf. So make sure you know that before you go to court. Otherwise, you may have to reset your case to find somebody else that is willing to do that. Now, if the judge grants you bond, it's going to come with conditions. Common conditions include reporting to a pretrial services officer, getting a job or keeping your job, not committing new crimes, notifying pretrial services before you change addresses. There'll be travel restrictions, drug testing, and in some cases, you'll have GPS monitoring. In addition, the court may require you to live or stay with a third-party custodian. It's important that you follow these rules, otherwise it'll cause problems down the road for you, both with your bail, it'll jeopardize your bail, and it may increase your jail time down the road. The key point is this: violating your bond conditions can make it much harder to get a lower jail term in your case down the road. In conclusion, you have a right to a federal bail hearing if Border Patrol agents arrest you for the federal crime of transporting aliens and your case is in either San Antonio or Del Rio Federal Court. You have a right to ask a federal judge to let you out on bond while your case is pending. More importantly, many of the most important decisions affecting your release are made before you even go to court for your bail hearing. An experienced attorney can gather favorable evidence, prepare witnesses, work with pretrial services officers, and present the strongest possible argument for your release. Alright, I hope this video is helpful. If it is, then please click the like button below and subscribe to our channel. Thank you for watching, and good luck.